I think my staying power is greater than theirs. Let's take a look at Rule 5. The court will not pass upon the validity of a statute upon complaint of one who fails to show that he's been injured by its operation. That rule doesn't apply in this case if we're talking about this trover action because it's a civil matter and there's no statute involved. Number 6, the court will not pass upon the constitutionality of a statute at the instance of one who has availed himself of its benefits. Now this is where I'm unique. We've already stipulated that I don't have a driver's license, registration, or proof of insurance, and that I own the property in absolute allodial freehold. There is no GMAC mortgage payments on that car. That car is mine. And I claim that property to the exclusion of everyone else in the universe, including God himself. And that's what the very definition of the word property means. And number 7, when the validity of an act of Congress is drawn into question, and even if serious doubt of constitutionality is raised, it is a cardinal principle that this court will first ascertain whether a construction of the statute is fairly possible by which the question may be avoided. Now, they're going to claim that the statutes gave them authority to take that car. And I'm sitting here saying, wait a minute, troops. Statutes and rules and regulations under Miranda do not apply. That where rights are involved, there can be no rulemaking or legislation that would abrogate those rights. And that's the horse that I'm on, and that's the horse that I'm going to ride to Washington on that particular issue. So whether it's civil or criminal, you've got to separate out the narrow issue and qualify that thing right from the scene of the crime to step 1, step 2, step 3, step 4. No matter what happens, you've got your rights issues that are qualified, and each and every one of these issues that you've brought up are issues that could gain you reversal when you go into the appeals process. All right, now let's drop that subject matter here for a moment. We now know what the appeals process is. It's an expensive, long, drawn-out, time-consuming effort on your part to reverse the decision of the trial court. And in the case of a civil matter, if you're judgment-proof, you can only win and you can't lose. That's why, while it's not against the law to be a pauper or poor, it's certainly advantageous if you're going to go into the courtroom. All right, I told you where it started, and that's with Moses. And how to post bond and plead not guilty. All right, we talked about that right off the bat. What you want to do, just to recapitulate now, at the sentencing, you want to make sure now that you either have enough money to post bond to stay out of jail if it's necessary, that you have your stay of execution pending appeal, and that you have your notice of appeal ready to go. And with this lesson, we're going to send you a sample notice of appeal, and we're going to send you the brief in support of that notice of appeal as a sample. That's so that you'll have a guideline to go by. After you've done one, you can do them all. And remember, the appeals process is no huge mystery, that requires 4 years in college to understand. Rule 54 is simple and straightforward. You simply look at it and it's going to say to you, and I'm going to cover that here in the second half of this lesson, it simply says step 1, step 2, step 3, and you're going to do it step 1, step 2, step 3. And if you can write a letter, you can write an appeal. Now, I want to talk to you about this thing of stipulating to the facts here for a moment, because stipulating to the facts reduces the entire process to the issues of law and separates out the issues of fact. Now, it may be that there are issues of fact that you'll want to keep into your case. If you want issues of fact, you need that trial transcript. Issues of fact, as an example, are contracts and deeds and all kinds of paper and evidence and things like this that would show that based upon the statute that your position is correct. You're a corporation, you're in some corporate capacity. As an example, maybe there's a foreclosure on your house. And during this foreclosure, there's a certain amount of facts that need to be adjudicated in front of the jury, and those facts will have to be appealed upon. That's a factual issue. Those are facts that must be brought out in the transcript and moved up through the appeals process. But when you're talking about the driver's license, registration, and proof of insurance, which we call the big three here, There are only issues of law involved here. I either have a right to drive as a matter of law or I do not. And I either have a right to that property or I do not have that right to that property. And so there are no factual issues. I don't have to sit here and say, well, did he have a license or didn't he? Was he validly licensed at the time the car was taken or wasn't he? Who cares? You see, the remedy for the government never was the conversion or the taking or the forfeiture of my property. You understand that issue? So since forfeiture was never a remedy available to the government, I don't care about the facts, whether or not I had a driver's license, registration, and proof of insurance. Now, however, if a person were a taxi driver and he were required to have the license, registration, and proof of insurance and the officer took his car, then it would be necessary as a factual matter to show from the record, yes, I did have a license, and here's the proof of it. Here's the dates, times, and places. Here's the signature of the Department of Law Enforcement. If he had insurance, yes, here's my insurance agent, and here's his testimony, and yes, the insurance was in full force and effect. You see, if you need those facts, then you would need that factual record to go into the appeals process with. It happens that in this particular case that I've given you the two examples of today, the driver's license, registration, proof of insurance is a criminal matter on the one hand, and I'm going to cover in a moment, and the Trover action, which is a property rights issue, can I have my property back? Those items are merely issues of law. And as issues of law, I'm going to sit here and open up the law book. I'm going to sit here and pull out my Constitution, my state Constitution, and say, this is where it's at, troops. And there are no issues of fact that any of these courts need to take into consideration. So in the two cases that I've shown you now up to this moment in time, when we go forward, we're going to talk about issues of law. We're going to ride that horse of property and this driver's license registration or this rights to drive on the roads as a matter of right, and we're going to ride that issue to the Supreme Court of the United States. I guess on the next issue we want to take up, let's talk about a demurrer, because that's exactly what a demurrer is. So let's pull one of those out. Take a look at that. A demurrer is simply a written stipulation of the facts. You're sitting here saying, in effect, and we're going to send you a sample here of a demurrer, which is an old common law term. I'm not sure in some states and some jurisdictions they're able to look at a demurrer and like they do a trover and call it a tort. And you'll be faced with this from time to time. You'll take a common law action and you'll file a common law action, and as the judge did in this case, he called it a tort under the Tort Claims Act, which was an error. And I would claim a procedural error if it goes that far. I've already done that, of course, but in a demurrer, what I'm really saying, in effect, is, yeah, I don't have a driver's license, registration, proof of insurance, so what? And the demurrer, then, is what sets the factual issues off to the side. There are no issues of fact in controversy. The policeman says I was driving without a license, and I'm sitting here saying, yeah, that's right. The policeman says I'm black. Yeah, that's true. The policeman says I'm black and was riding the front of the bus, and that's true also. So what? And that's your demurrer, and you're going to walk into court and say, okay, this is the demurrer. I'm going to demur to the action. I'm admitting all of the facts, but I'm contending that I'm not guilty for this reason. You can't make a black person ride the back of the bus. So there's your demurrer. Now, an appeal on the errors of the trial court, I think I've covered that one fairly well, and said that's a factual matter over here. You'll need the record if you're going to appeal on the errors of the trial court. Now, most of the time in the past, we've always demanded, especially in the lower courts, we've said, well, we demand a transcript because we know they don't want to pay the money for the transcript. And when they refuse to pay the money for the transcript themselves, that forces them to sandbag or to drop the issue in the district court. Because after all, I don't need the transcript. It's the appeals court that needs the transcript. I've always maintained the position, well, I'm appealing on these issues. If you want to listen to the tape recording, you go ahead and listen to the tape. We all know, as a matter of practical fact, that you cannot listen to a tape, and then go through and go back, and like you can when it's written down, you can go back 10 pages and underline what somebody said, and then we'll say the same thing over here and underline the discrepancies. It's difficult to do when you're listening to it. However, they made the transcript on tape. I didn't. And so if you want that transcript written down, then it's up to you to go get that transcript. And this is especially true if it's a criminal matter. If it's a civil matter, it's a tougher row for you to hoe, because they're going to demand that you pay for this because it's a money issue. It's civil, not criminal. As a matter of criminal rules, you have a right to these things. And so you can't put me in jail and then charge me $4,000 for a transcript. And the jury instructions are really a dynamite issue for appealable issues of error in the trial court. Now, remember when we talked about juries, we talked about jury instructions, and I think it's worth mentioning at this juncture of time that, let's say you file 20 jury instructions, and you're instructing the jury as to matters of law as it pertains to the facts of this case. And remember, we covered that and how that goes together and how you do that. And the trial judge, for whatever reason, fails to put a key jury instruction in. I can show you dozens of cases that have been reversed on appeal or remanded back for retrial on the issue of jury instructions. And I would say that jury instructions are probably the most formidable, the best, the number one reversible error issue that you can come up with. The courts will, go, well, gosh, is this really a violation of a constitutional right? And they'll sit there. The lower courts do not like to make reversals on constitutional issues, but they will make reversals upon jury instruction issues. They'll do that a whole lot faster and a whole lot easier than they're going to make it on some major federal question like Article 1, Section 10, counsel, juries, issues like informations and grand juries. These major federal questions, the lower courts like to slough off and let the higher courts make those decisions. It's just like any other corporation, if you stop and think about it. The lower echelon management, gosh, I don't know, if I make that decision down here, it could hurt my career later. I'll slough that off and let the next level make those decisions. Now, another thing that occurs, and I think it's time to bring this up, is frustration and laziness. The more this drags on and the longer it gets and the more paper that you have to write, the more tendency there is to give up and quit. And that's why I say I just need 300 good men that can stay the course. Because, as I've said, I don't know how long it's going to take to win, but I know that somewhere between 1 and 100, you're going to surrender. The eloquence of my argument will make itself manifest in your bank statement, and I think that your common sense will tell you that it's time for you to give up and quit. Now, when we get warriors like that out there on the courtroom floor, we're indefeatable. But on the other hand, if you get into the appeals process and they're compelling you to write briefs, and this is oftentimes the case, and I saw it yesterday, and this was really hilarious. It was the day before yesterday, I went into an arraignment, and I filed about 25 motions, and briefs in support of those motions on another felony matter that concerns me. They charged me with stealing traffic tickets in the traffic court, and boy, they're really hot to put me in prison over that one for, 28 years for taking 2 traffic tickets, they are alleging. And I noticed that the judge, in this case, I think he sensed the frivolousness of the state's position. He's sitting here saying, my God, but his position is, well, if the state's going to prosecute, I've got to do my job. I'm the referee. So he ordered the state to respond in writing to every one of my motions and briefs. Do you know how much writing that is for a man to accomplish? Mine comes out of a computer. Let me show you something. Take a look at this case file. That thing's 2 inches thick. There must be, 2, 3, maybe even 400 pages. Every word in this file that's written by me, not the responses by my opponents, but every word written by me, is on computer disk and can be reproduced probably in 3 or 4 hours. But if I write a 26-page brief and I bring up some 40 points, my opponents have to do the same thing. See, they have to respond. They have to answer each and every one of those points or lose them by default. Because if they don't answer, in other words, if I bring up the subject and say, your shirt's blue, and you don't deny that it's blue, then it's agreed that it's blue. And by the rules, all blue shirts go to the defendant, so take your shirt off and give it to me. So I win by default on that issue. All right. Now, it's for that reason, then, that I think that this judge did that to the opposition. He's saying to them, in effect, okay, if you guys are serious enough to want to prosecute this case, let's see you answer all of this guy's arguments. Let's see you overcome his arguments with Supreme Court case law. Where's your points and authorities? And that's important for you to do. But on the other hand, it may work just the opposite way. What if the judge requires you to do that? Are you going to give up and quit? Because as long as this case is in appeal, you cannot lose. It may just die, which is a lot of times what will happen. I had a case not long ago that the judge said, I'm going to get back, I'll give you a written opinion. That's been about 90 days since that written opinion was due. Well, I think I've waited about long enough. I know that that judge is hoping against hope that I'll just forget it. I know that my opponents want to forget it. I mean, they just want to wish and hope that I'll just dry up and blow away. And that's either a sleeping dog or a dead dog. I'm going to kick that dog. If he's asleep, I'm going to wake him up, and if he's dead, I'm going to stir up all the maggots in the carcass. And that's the way that's going to come down. That judge is not going to get off the hook. You see, I'm going to prosecute that issue to the Supreme Court of the United States, or my opponents can surrender. Anytime they want to surrender, I'll accept their defeat. And in the meantime, I'm going to take it to Washington, and the principle is total victory or total defeat. And if you're not prepared to go forward to total victory, it would be better if you didn't even raise the subject. It's better for all of us to let that sleeping dog lie unless you're prepared to go to war all the way. And I am, and so by the time they get through with that case, I'll tell you this, next year when I file a case, they're going to say, we know that George Gordon will always take his case to the Supreme Court of the United States. We know that every time we go to battle with him, it takes 3 years and $60,000. We know that he will never surrender under any circumstances. You see the kind of psychological damage I do? Look back in Scripture and you'll notice, and this is where I picked this up, and I want to pass it on to you because I think it's extremely valuable. When those Israelites went over into the what's called the Promised Land, the first place they hit was Jericho. And they marched around the city for 7 days, and here's the way it came down. The city walls fell down, and they killed every man, woman, and child, every dog, cat, and horse. They destroyed everything in that city. Then, can you imagine the kind of stark terror that must have gone around to the rest of the cities? For instance, let's say I live here in Boise, Idaho. What do you suppose would happen if we're sitting over here and word comes in that the city of Nampa has been surrounded by an alien force, leveled to the ground, burned to ashes, every citizen killed, every dog, cat, and horse absolutely destroyed? What would be the first question on my mind? Which way are they headed? East. Uh-oh. Meridian's next, then Boise. Gee, I might say, well, probably they won't destroy a city like Boise. So the first time comes down. Now the next city they came to, I forgot the name of it, we'll call it Ai. I think there was a town called Ai. They got to that town. They did the same thing. They killed every woman, every man, every kid. They killed every dog, every sheep, every cow, every pig. And they burned everything else. If the word came to Boise, what happened in Meridian? The same thing that happened over in Nampa. Which way are they headed? East. I'm sitting here going, gosh, twice in a row now. Look what they've done. Do you think that would create some stark terror? That's why it's so important that it always be total victory or total defeat, because when you've totally vanquished somebody and then opened up the wound and poured salt in and then sewed it back up and said, how'd that feel, dummy? When that happens once, then twice, maybe 3 times, maybe 4 times, that says to me, uh-oh, The reputation that this fellow has is that total victory or total defeat. And I always like to tell my enemies that from time to time. Total victory or total defeat. Then they face guys like Hallstrom and Cook and Potts and Kruger, and on it goes. And so the word spreads around in the legal circles of Ada County, and they say these people will accept nothing short of total victory or total defeat. Don't sit here and threaten to throw them in jail because they'll put their hands behind their backs and say, follow me. They know exactly what to do, and they know exactly how to handle it. Now, we've covered that. Now, you get to the appeals process, and it takes you a year between, the scene of the crime and the appeals process, and it takes maybe into the second year before, in your county, 4 or 5 people get their appeals in, and they begin to recognize that these people will never surrender. Never surrender. Because yesterday I noticed when we walked out of the courthouse, serious conversation going on. And I know exactly what they're talking about, because if I was in their place, I know exactly what I would be talking about. I am faced with 3 more levels of appeals. I am faced with an opponent who hasn't got intelligence enough to give up and quit when he doesn't have a chance. And in the meantime, while I know that I'm more competent, I know that I can defeat him, he keeps bloodying my nose and blacking my eyes. And the question is, how much money do we want to spend on this guy? Don't you think it would have been more logical to just pay this guy the $1,600 for his Chevrolet automobile and the $1,500 for his motorcycle? At any time they could have walked over and paid me $3,000, and I would have smiled like a clam at high tide and taken the offer, and they would have been through with me a year ago. And at this moment in time, they're in $7,000, and there is no end in sight. Got that? No end in sight. Now, let's go on now to some technical aspects. I want you to turn to Rule 54. You should have the Idaho Rules of Idaho Rules of Criminal Procedure. Go ahead and turn to that. Some of you are going to have the binder edition, and some of you will have the little small book. Let's take a look at a simple rule. Now, by now, you people should be competent to read rules. You've gone through a number of rules, Rule 16, Rule 5, you've filed motions, you've been writing motions, you understand motion hearings and how to notice them up in one thing and another. Let's just take a quick, brief perusal here at Rule 54. We're getting toward the end of the rules. I want to point out some crucial factors now to you, because these rules must be followed to the gnat's whisker. Any error on your part on this rule is going to weed you out. And I want to caution you on this. If the rule says 42 days, friend, don't file it on the 43rd day. Because if you don't follow the rules right here, the Supreme Court has a history of weeding you out. You're just the other 50%, man. You didn't do what you were told down here at the lower level. We're not going to listen to your appeal. You can have this gigantic federal question. You can have this just real nifty issue that the Supreme Court is just drooling to listen to. And remember, if there is any other way that we can dispense of this, we will. And let me tell you, they're going to make you dot every I and cross every T. Fortunately, they're only holding you to the standards of a lawyer. Thank God they're not holding you to the standards of competence. Taking a look at Rule 54, on page 475, says here, appeals from a magistrate to a district court. Here's your first level of appeal. Appealable judgments and orders. Bear in mind now that if you're in Illinois, you'd better be on your Illinois rules, right? But I want to use the Idaho Rules of Procedure because generally throughout the land they'll be essentially the same. But let me tell you, there's going to be some I's and T's that'll have different punctuations, and that's what you've got to watch for. It says appealable judgments and orders. Okay, you have to appeal judgments and orders. If the judge, you may not have been to trial, you may have an order or a judgment, a judicial determination. It may be incumbent, like with Rick, We made a strategic error there, and I brought that up in Lesson 29. It says, oops, we got an order from a judge and we didn't appeal his order. Slipsies on our part. And so, while that judge said, well, I'm going to rule that you're a taxpayer, he should have appealed that judicial determination and said, no, I'm not a taxpayer, and he should have appealed it immediately, and he didn't do that. Okay, so judgments and orders then. And there shall be no direct appeal from an order or decision of a magistrate to the Supreme Court. Okay, so don't go from the lower court straight to the Supreme Court. You must go in line, like I said, A, B, C, D. Provided, however, that whenever the Supreme Court, upon petition of the administrative district judge of a judicial district, assigns an attorney magistrate to hear any felony action, any appeal taken from a judgment of such magistrate action under such order shall be made to the Supreme Court. So here's an exception. Okay, so you can read the exception as well as I can. An appeal may be taken to the district judge's division of the district court from any of the following judgments, orders, or decisions. Now watch. You appeal judgments, you appeal orders, you appeal decisions. Those are the magic three. Judgments, orders, and decisions. A judgment is, you've been found guilty and my judgment is 30 days in jail and a $300 fine. You appeal that. You have an order. I'm going to order you to specifically perform. No, I don't want to fill out 1044 amount. You appeal that order. Or decisions. You have a judicial decision, let's say. You appeal. You say, the trial court says, no, you can't have counsel, and you appeal that decision. You know, theoretically, a guy could take a decision like that, and he could move a decision up through the ranks to Washington, and Washington could come back and say, yeah, you've got to give him counsel before you go to trial. This appeals process works before the jury verdict, even. I've made appeals to the district and the Supreme Court on issues before I've gone to trial, and the purpose for that is to get a judicial determination to force the trial court to do a specific thing or to grant me a specific right. Now, there are 6 items here, so let's just, see, there's 7, 8. I want to read up here to line 9, because when you get up to line 9, that's called the notice of appeal. And a notice of appeal, I'm going to send that along in this lesson. It's simply 2 pages, and it simply runs out here through the first 8 paragraphs. So between item 1 on page 475 and item 9 on page 476, I'm simply going to follow the directions that are given here. And it's just as simple as making a Betty Crocker cake. It just says, step 1, get a bowl. Okay. Step 1, bowl. What next? Get 3 eggs. Okay. 3 eggs. Now what? Break eggs in bowl. Okay. Plunk. That's exactly what you do. You follow these rules line by line, item by item. I don't know how many people that I've seen do this. They'll fail to read the rules, or for some reason, they just get it in their heads. Well, I'm in a hurry. I've got to be at the beauty parlor, and I'll put that off until tomorrow, or I'll do this later, or I'll just skip that. Gee, I wonder if I have to do that. All right, item 1, final judgment of conviction is what you're appealing from. And so number 1, I say this appeal is made within 42 days of judgment or order. Okay. Item 2, by a defendant only, from an order granting or denying a withheld judgment on a verdict or plea of guilty. Okay. Number 2, this case was heard in the Magistrates Court of the 4th Judicial District, Traffic Division, County of Ada, State of Idaho, and the presiding judge was Hamilton. Okay. I'm the defendant. An order granting a motion to dismiss a complaint. An order granting a motion. I'll just read through these here. I don't need to follow through each one of these items. An order granting a motion to suppress evidence in a misdemeanor criminal action. An order denying a motion for a new trial. An order made after judgment affecting the substantial rights of a defendant or the state. Number 6, I've appealed on that one on the counsel issue. I've had judges in the magistrate court say, no, you can't have counsel of your choice unless he's a licensed lawyer, and I've appealed that. Sometimes that gets sandbagged. When the judicial process does not want to listen to issues and they just want to get rid of you and get you out of their hair, they'll let you have a victory by simply sandbagging your issue. Number 7, any order, judgment, or decree in a special criminal proceeding in which an appeal is provided by statute, and any order holding a person in contempt of court other than those contempts defined in Rule 42A. Time for filing appeals. All appeals permitted or authorized by these rules may be made only by the physical filing of a notice of appeal with the clerk of the district court of the county wherein the magistrate trial was held within 42 days from the date evidenced by the filing stamp of the clerk of the court on the judgment, order, or decree appealed from. So here's what you do. There's got to be a written judgment, order, or decree. There'll be a file stamp on it. On the 42nd day, in other words, let's say it's dated July 12th, then the first day is July 13th, and the second day is July 14th. On the 42nd day, you'd better have a file stamp on your notice of appeal in the state of Idaho. Now, in some jurisdictions, it may be 30 days. It may be 30 working days. It may be 30 days including holidays or excluding holidays and weekends. I mean, they've got all kinds of nifty little rules in different jurisdictions, so watch that timing. That timing, I've seen a number of people foul up on their appeals by not getting that appeal in correctly on the right days. Now, we get up here, we're up here on page 476 now. When we get to this notice of appeal, it says the title of the action or proceedings, and here's what I had to have. I've got a title of the action or proceedings, and it's called the notice of appeal. The title of the court which heard the trial or proceedings appealed from, and the name of the presiding magistrate. And number 2, this case was heard in the magistrate's court. In other words, you see, I'm just simply filling in the blanks, so to speak. This is just rote. It's just mechanics. You don't even need to be a lawyer to do this kind of thing. In fact, we have this portion of it computerized, so we can spit out a notice of appeal with your name and address on it and your case number in 1.5 minutes, I think. So you go through these 8 items. Now you come up to item 9, and now the thing starts to get more complex. Now listen to number 9. A statement of the issues on appeal which the appellant then intends to assert in the appeal, provided such statement may be filed separately within 14 days after the filing of the notice of appeal, and any such list of issues on appeal shall not prevent the appellant from asserting other issues on appeal thereafter discovered by the appellant. Now, let me give you an illustration of that. I filed an appeal. I filed a demur and said the only issues are issues of law. The district court said to me, yes, we will listen to that. We're going to listen to that appeal because they don't need a trial transcript. All they're going to listen to are the affidavits, motions, and the legal arguments. I filed my notice of appeal. I filed a brief in support of the appeal. And now, up to 5 days prior to the appeal being heard, and in this case I think it's August the 6th, they're going to listen to my appeal. Or August 5th, I've forgotten exactly the date. I can file additional information. In other words, I've got my appealable issues, the brief in support of appeal, but, you know, there may be some new matter that comes up, new case law, new information that I'm researching and putting in. And I have to give my opponent an opportunity to respond to that. Now, it may be 10 days in your jurisdiction, or it may be 15 days. I don't know what it is. Check it out, and it should be right here in Rule 54. But I think in pursuant to our rules, I think I have up to 5 days with which to put it in. Now we'll go in and we'll argue our positions, our appendixes, our case law, and everything before the appeals judge. And the judge will look at it. In this case, it's a woman. And she'll look at it and she'll say yay or nay to me. But I have a judicial determination, don't I? Then I have 42 days with which to appeal that decision to my state Supreme Court. Now, the state Supreme Court has the rules of the Supreme Court of the state of Idaho. And its rules are a little different than these rules. So now you've got to pull that rule book out and say, okay, item 1, item 2, item 3. Now when you file an appeal to the state Supreme Court, they have more stringent rules pursuant to the cover. As an example, you have to have a hardbound cover, and it's got to have an appendix to it, and it's got to have nomenclature, and it'll spell it right out in the rules. Sometimes I've noticed that some of our citizen pro se's, when they see all of this writing and all of these rules that they have to adhere to, they get discouraged at that. And they say to themselves, oh gosh, and then they let the appeal time go by. And then all of a sudden comes, the realization, and the realization comes when it's remanded back for execution of the sentence. Remember, if you fail in your appeal and it's remanded back for execution of the sentence because of a technical violation over here, the higher courts now will keep remanding it back because of a technical violation, and now you're at the mercy of the trial court judge who probably doesn't like you too well anyway. And that's the thing in my mind that always keeps the prod on me. I always look over my shoulder and I say to myself, I don't want to ever have to face that guy again. And that prods me on to appealing to the next court and the next court. And the higher up it goes, and the more responses that need to be taken. For instance, I live here in Idaho, and let's say we're going to argue this case before the Ninth Circuit in San Francisco. Well, I'm an indigent, so I'm going to file a notice of demand and a need for air transportation, motels, and accommodations in San Francisco, am I not? And I'm going to need counsel while I go down there, and so I'm going to have counsel and accommodations for my counsel. Now, the state of Idaho doesn't want me to go to San Francisco, and I know that. And I know they want to weed me out in the worst way. So I'm sitting over here saying, okay, I'm going to keep it going until they give up, not me. So far, in 5 years, my opponents have always given up. And I've never had to go beyond our state Supreme Court. I've lodged a couple of appeals over there, but I've never had them heard. Okay, so the rules that you go upon here, are simply the rules that lay out, and I'm not going to sit here and waste everybody's time. Over here on Rule 481, on page 481, let's take a look at this. I've underlined it where it says, the failure to physically file a notice of appeal or notice of cross-appeal with a district court, each within the time limits prescribed by these rules, shall be jurisdictional and shall cause automatic dismissal of such appeal upon the motion of any party or upon the initiative of the district court. And let me tell you, the initiative of the district court, you won't have to tell them twice to dismiss. Now, that's why it's so crucial to get the time limit down. And there are other rules in here, too, as to the form and the effect of it. Take a look at this brief in support of the appeal. Pull that out. And you've got a notice of appeal with this lesson, and you've got a brief in support of the appeal. And it's called a statement of the facts. And it's about 7 pages long. And you'll notice that it's notarized at the end. I think this notice of appeal is also notarized. No, it isn't. I believe your notice of appeal probably ought to be notarized, and the brief in support of the appeal ought to be notarized. I think that's one of the rules that you'll find here in Rule 54. Let's just take a look at some of the more salient facts or issues that are brought up in a brief in support of the appeal. An example of it is, let's say you're going to appeal on counsel. You were denied counsel. You write a paragraph in your own counsel. It is not necessary for you to write 26 pages on counsel in your appeal brief because that's superfluous. All you need to do is to go down your list over here and just write a brief paragraph subject to motion to appoint a public prosecutor. That's your prosecutor issue. You've got a prosecutor brief. You've got a prosecutor motion in here. I would write about 1 paragraph, maybe it's got 15, 20 sentences in it that simply lay out the essentials and says, please see my brief in support of the motion to appoint a public prosecutor. Anyway, just kind of reading on through here, it's a pretty standard brief and motion. It simply says, comes now the defendant to move the district court to reverse the conviction of the defendant in this instant case for the following causes. Okay? So we've got a motion here. And we've got a brief. That's all it really amounts to. It's called an appeal brief. It's called an appeal, notice of appeal. The defendant was found guilty of driving a car without registration or proof of insurance. The third charge of failure to display a driver's license was dropped when the prosecution could not prove the defendant was in fact a licensed driver. They didn't want to address the driver's license issue. The defendant stipulated to the facts as follows. I have no driver's license, registration, or proof of insurance. The defendant so stipulated both at arraignment and in the trial court. The prosecution, now that's your demurrer. Say your demurrer said, yeah, so what? The prosecution insisted upon moving forward in a jury trial over the objection of the defendant. The defendant refused to plead, challenged the jurisdiction, and demanded all of his rights. You see, just the essential facts. The defendant suggested the case be sent to the district court to hear the issues of law and constitutional rights, all to no avail. The prosecutor in this case wanted to put another notch on his gun and get a jury conviction. To which I say, big deal. There are no issues of fact, only issues of law. This case and the issues of the driver's license, registration, and insurance is only one of 6 cases which have been taken to the district court in an action for declaratory judgment. The case is 81358 and is going to be heard by Judge Newhouse. Several motions were filed and denied. Defendant contended that he is not a person required to have a driver's license, registration, or insurance. What am I saying? I'm contending that I'm not a person who's required to ride the back of the bus. I am stipulating that I am black. I am stipulating that I rode the front of the bus. And I am stipulating that that's a violation of statute and blah, blah, blah. See what we're doing? Very simple, straightforward procedure. Now, we come to the second portion of it, the mechanics of the brief, which says the appealable issues. Okay? Well, remember, these appealable issues are going to be different in every case. The appealable issues is this entire nomenclature. If you refer back to Lesson 9, there was 38 items. Of the 38 items, let's say 20 of them are motions for some item. One of the appealable issues may be Rule 16. Another appealable issue is notice and demand for right sua sponte. A third appealable issue is notice and demand for counsel of choice. And so on down the line. There may be 1, there may be 20. Now remember, in the Almeida Sanchez case, he had one appealable issue, and that was the search and seizure issue. Well, if you'll notice over here in Lesson 9, I might have 20 issues, including search and seizure. Okay, we're on page 2 here, called Appealable Issues. The defendant made a notice and demand for dismissal pursuant to statute. An order for the dismissal of the action as provided in this chapter is a bar to any other prosecution for the same offense. That is, if it's a misdemeanor. But it is not a bar if the offense is a felony. Okay, we have a statute in this state which should have dismissed these charges against me because they've been brought over and over and over again, and they're the same charges. And while it's not double jeopardy, we have a statute that says, look, if it's been dismissed once, it can be dismissed again and again. And this particular magistrate said, no, I'm going to go ahead and try the case. So when I go to the appeals court, I'm going to say, hey, it ought to be dismissed on this statute alone. And I've had it dismissed before on this statute alone. And I'll bring that up in the oral argument to the judge and say, look, Judge Smedley over here dismissed based upon this statute. This other magistrate didn't. And so I'm coming to you and saying, I think Judge Smedley ruled correctly when he dismissed this. It's been tried over and over again. And it's been dismissed over and over again. And so we go on, and there's one of the appealable issues. Number 3, then, we've got the counsel issue. And I wrote in here a few key counsel quotations from the Supreme Court of the United States. And I raised the counsel issue, and you can read that for yourself. And then item 4, the prosecuting attorney issue. And I raised the prosecuting attorney issue, and I said it should be reversed on that indicia. And item 5, the driver's license issue. Please refer to my brief on driver's license is evidence of consent. In other words, see, I don't need to sit here and write a 12 or 14-page brief. Just refer to it. Now the judge will open up and say, oh, okay, driver's license brief. Oh, okay, now that judge can read that driver's license brief. Item 6, demur and demand for dismissal. I filed a demur. The major federal question. Now, this is the one where I file the appendix So what I'm going to do next, I've got everything in except the appendix. So I'm going to go up and file an appendix to the brief in support of the notice of appeal. And I'm going to put that whole driver's license issue with about 500 cases in before this judge, and I'm going to go argue it. And when we go to argue it, I'm going to bring up the Supreme Court of several states and the federal Supreme Court and my right to travel in the whole 9 yards. And then the judge will be faced with, do I want to rule against Gordon? Because if I rule against him, I know he's going to take me across the street and up the line forever. Or do I want to rule for Mr. Gordon? And if I rule for Mr. Gordon, I could be opening Pandora's box, and every driver in Ada County will throw his driver's license away. So what you're doing, in effect, is putting the judge in the same position as Pontius Pilate. You know, I don't want to kill the guy because he's not guilty, but on the other hand, if I don't give him to the people, it won't look good to Caesar, and I won't get a promotion next year. I may not get a merit raise. You know, Pilate was a good bureaucrat, and so some of our judges are good bureaucrats, but some of our judges also know and understand constitutional law. And if enough of us, and I'm not saying thousands of us, I said enough, 10, 15 people. You know, it only requires about 10 or 15 people, to my estimation, maybe 30 at the most. Good, competent pro se's operating in any county, going into those courts regularly. I mean, once a year out of the 15 or 30 that you've got. And there's 15 to 30 lawsuits a year, 15 to 30 constitutional questions a year. Pretty soon, the lower courts will have to start making those decisions pursuant to the Marbury Doctrine, because if they don't, it floods the higher courts, and pretty soon the state Supreme Court says, "What's the matter with you dummies over there? Can't you make decisions?" Now, that hasn't been done in America for 75 years. Citizens have not been taking their issues to court, and it's time that they started doing that again. And that's why here in Ada County, I just got word in the newspaper the other day that they're going to have to hire some new judges here to hear all these appeals that are coming around. Gosh, I wonder where all these appeals are coming from. I'll tell you where all the appeals are coming from. They're coming from citizens, people just like me and people just like you. And you know, every appeal that goes in there, they're sitting there, "Oh, we'll just dispense of this housewife from Cuna. Why, she's dumb. She can't chew gum." And pretty soon you get this housewife from Cuna walking in there with good paper. We've got a housewife that can chew gum and talk at the same time, Judge. And I want my issues listened to. And all of a sudden, oops, gosh, now I've got to listen to this woman. And whether he's an unjust judge or not, he's sitting there saying, I've got to listen to this case. And the reason that the lower courts will be compelled to listen and make these decisions at the lower level on constitutional grounds is because the higher courts, remember, have less and less available resources to do it. Now watch this scenario.